Hi everyone, my name is Zainab Williams from Elleverity, and today I'm excited to chat with Reshana Singh from Lockyer Hein, and she's just going to be sharing with us amazing details regarding estate planning. So Reshana, just please give us a brief intro, and I'll ask you a couple of questions regarding estate planning and why it's so important.
Great, thanks, Zainab. Well, as you mentioned, my name is Reshana Singh. I'm a wills and estates lawyer at Lockyer Hein LLP. We have three offices. One's located in Brampton, one's in Caledon, and one's in Georgetown. I also practice in the area of real estate. So today we're going to go over some points on estate planning and answer any questions that you may have as to how, what the best way is to get this done for our clients.
Okay, fantastic, Reshana. So the first thing is, what exactly is a will and what's the purpose of it, especially when we're talking about wills, the powers of attorney, and also personal care?
Right. So what a will is, and let's say a will and power of attorney documents fall under the umbrella of what's called estate planning. So during the estate planning process, typically what we do is we meet with our clients and we try to get a holistic understanding of what their needs are. Talk about what their family dynamics are. We talk about the assets that they're holding at the time that they're making a will, how they hold their investments. And then we get to, how would they like their estate just distributed and who's in charge. Essentially, the function of a will is just that. It's you determining who's in charge when you've passed away, and essentially where does your stuff go? Who gets, who inherits your estate? Again, as I mentioned, the will governs when you've passed away. The power of attorney documents that are under this umbrella of estate planning, they are for when you're alive but incapacitated, so no longer able to make your own healthcare related decision making or financial related decision making. You do a power of attorney for property that deals with your finances, and then a power of attorney for personal care that deals with things like clothing, shelter, hygiene, nutrition, and your general healthcare related decisions.
Oh, I see. Can the power of attorney be anyone, or what exactly is the process for choosing a power of attorney?
So power of attorney can be anyone. Typically, when I meet with my clients, if they're married or they have a partner, typically partners will pick each other as their powers of attorney or as their executor or estate trustee. So that's the person who's going to manage their affairs of their estate and execute what was in the will, what your wishes were in your will. You can designate anybody. I recommend these days, we may want to name our children, we may want to name a close friend, someone who we trust, because the power of attorney authority is a significant authority that we're going to be granting to someone else. We're giving that person essentially the ability to make decisions on our behalf. They can do anything that we can do except for make a new will. So they can buy property, they can sell property, they can open accounts, they can close accounts, they can pay your bills. They'll be able to file your taxes for you on your behalf and go to Service Ontario if you need to renew your plates. They'll essentially be able to step in for you in the event that you are no longer able to make your own decision.
Wow, that's a huge responsibility, right? Especially when you're handing over someone, essentially your life's purpose and assets. But so is this, in terms of the will itself and the power of attorney, who needs it?
I tell my clients, I think everyone needs it. Just, anyone who wants to take the decision-making process into their own hands is the person who wants to make a will. If you pass away without a will, the law determines who's in charge. The law determines, where your inheritance goes. So in essence, when you make a will, you get to say, who do you want to manage your estate? You get to say who gets what. If you want to give any gifts, you get to say who gets the gifts. If you want to distribute, evenly or unevenly between children, between, partner, etc., you get to make that determination. And in my opinion, that is the most personal decision that should be made. And, I don't necessarily think that the law should be the one that person or the thing that decides, who gets to make those determinations on your behalf.
Absolutely. So that if you don't have a will, what happens?
So if you don't have a will, the court actually will have to either, if you have assets that need an estate trustee to be appointed in order to deal with those assets, or the distribution of those assets, the person who is going to be in charge of your estate is going to have to go to court and put together a court application to apply as in that position. And that is extra legal costs, that's extra time that doesn't need to happen, and that can be mitigated by meeting with your lawyer or having a will and estate plan done and drafted for you ahead of time.
Okay.
Another thing, another point to consider as well as for who should have a will is, if you are a parent and children and you want to make that, that very, very, very important determination as to who do you want to be the guardian if something were to happen to you and your partner or your spouse, that's something that we can do in the will for you as well. If you'd like to create a trust, if you have a child who suffers from mental health issues or from a disability, from addiction problems, we can create trust. There are protections that we can put in place in the will that will help those people manage that wealth or that transfer of wealth that takes place when you pass away and you want to leave your inheritance to those people. The will can help to govern that as well. If you own property and you want to say who inherits the property or who has the right to that property, your will can do that as well. Again, if you want to leave gifts to any charities, that's the place to do it.
Absolutely. I love that, because a lot of the times we usually forget about this important document, and it's something that is critical, especially when you've lived all your life, you've worked so hard,
Yes.
and at the end of the day, you don't have this amazing document to really distribute your legacy to people who you care about. And I often hear that people don't want to pay probate fees. And what exactly is a probate?
So that's a very good question. And during the estate planning process, oftentimes that's the number one question I get from my clients is, I ask them, are you familiar with probate or what the probate process is? And for the most part, unless you have to experience or go through that process yourself, a loved one of yours has had to go through that, or you've been personally touched by that issue, it's not something that most people know about. Probate is a requirement of let's say the bank or certain investors, where you actually have to put an application together and have the court either validate a will that you've already created.
Mm-hmm.
The court can make the determination that yes, this is in fact the most recent and valid will of the deceased, and that the person, that the will is done in a correct way and that it's been executed accordingly. And then you can take that court order that the court then gives you back to the bank and show them, yes, the will has been validated, and yes, if I'm the estate trustee, I have the authority and the ability to bind the estate. I can manage the assets, I can distribute to the beneficiaries, I can file the taxes, etc., etc. The bank is not going to release funds. So what falls under the umbrella of probate is a good question. And those assets are anything that you hold in your name alone. So assets that are not jointly held, investments where you cannot name a beneficiary, or property that you own in your name alone. Those are the three kind of biggies there. If you own them jointly, then via right of survivorship, that interest is automatically transferred to the surviving person on title or the surviving person on that account. But if you're the only person on that account, and let's say there's $1 million in that account, then the bank doesn't want to have to be the person to make the determination to say, okay, say for example, I come to the bank and I say, here you go, bank, here's Zainab's will, I'm the trustee, I'm the beneficiary, empty all her accounts and give me everything. Yeah. And then the next day, your partner goes into the bank and says, here's Zainab's will, empty her accounts and give me everything. I'm the beneficiary. And the bank has now made a huge mistake by, releasing everything to me initially. Mm-hmm. They don't want to have to do that from a risk management perspective. So they say, go to court, get that will validated, and make sure that, yes, it's valid, it's the most recent will, and then we will act on the orders of the court. Any asset that has to go through probate is subject to probate tax, as you mentioned, or state administration tax is what it's called. the government, in order to go through this process, takes a 1.5% tax on the total value of all your probatable assets. So if you have your total value of your probatable assets $1 million, then you would be saving, you know, by doing some proper estate planning, you could potentially save your estate $15,000 worth of probate tax, plus the legal fees that are come with that on top of that. So it's a significant amount of money that if you do a little bit of estate planning ahead of time, you may be able to mitigate the need for the necessity for probate when the time comes.
So based on what I heard, so in terms of reducing probate, so having beneficiaries is a key factor, and also the joint ownership. Correct. And I think life insurance also, in terms of just designating the beneficiary of your policy to someone else, right? So it's kind of avoids the whole probate structure. Okay. So then I really wanted to go back to the powers of attorney, because I really think that's important, especially when you are at an age where you have suffering from medical concerns. So let's say, for example, you feel like someone is misusing their power when it comes to your assets. Can you say or do anything because you've already signed over that document?
So your power of attorney that you grant at the time that you make your will and that you make your power of attorney, you have to have the requisite capacity to do that. So you have to be aware of the nature and extent of property that you own, the assets that you have, any obligations that you have to any dependents. You know, you have to have that proper testamentary capacity. That can be revoked at any point in time. You can make a will today at my office and then go tomorrow to somewhere else and then make another will. And as soon as you sign that will, it invalidates the wills that were done prior. Or the power of attorney, it can be revoked at any point in time as long as you have the requisite capacity. So power of attorney for personal care are inherently a capacity document. And that just means that you have to be deemed medically incapable by a professional in order for that document to take effect. So while you're able to make your own healthcare decisions, you will be making your own healthcare decisions. It's only at a time where now you've been deemed incapable that that document can take effect. Okay. The power of attorney for property, which deals with your financial related decision making, does not have to inherently be on your incapacity. It actually can be effective immediately on signing. Where we would include a clause that says this power of attorney is not subject to any conditions or restrictions. And that means as soon as you sign that document, whoever you've named as your power of attorney will have that authority immediately on signing. So for some of our elderly clients who, you know, their mental faculties, they may have their mental faculties about them, and that's not an issue. But physically, you know, they're unable to make it to the bank. They're physically unable to get to the Service Ontario to do those things. In that instance, a power of attorney is extremely useful and helpful in order for their adult children or their partners, etc., to be able to act on their behalf. When you sign your power of attorney, you are accepting that there is a possibility that this power of attorney could be misused, but I always recommend that the person you're appointing, you believe, has genuine care and concern for your well-being. And if it is that your family members see that, you know, they may believe that, you know, this person is a power of attorney or this person is an estate trustee, and I don't know if they're handling, you know, things in the right way, they can, you know, there's always a litigation route where you can ask for a power of attorney to account. They have to provide a detailed accounting for every penny in and out of that person's account. As an estate trustee and executor, you are obligated to provide a detailed accounting of every penny in and out of that estate account. So, you know, there is some form of liability and accountability that's there for those individuals who act in that capacity.
Okay. I'm glad there is something out there to protect people, right? Because it is critical to have someone who you trust be able to take care of you. And if that trust is misused in any shape, there is some sort of protection for yourself as well. Absolutely. And so, Reshana, in terms of this whole pandemic, what exactly has your office been doing in terms of just adjusting and helping clients out during this difficult time?
So, you know, the law is one of those slow and steady things to change. it's been interesting to see how the legal profession has managed to, or tried to accommodate and change with the current time. So currently, the courts have put forth an emergency court order that has allowed for the video and audio execution of wills. So, prior to COVID, we would meet together for our first intake appointment. I would take all your information. We would put together our estate plan. It would take a few weeks to draft. And then, again, it's a collaborative effort. We would get you to work with your accountant, with your investment advisor, with your insurance advisor to make sure that we're putting in all the protections that we can and creating a holistic estate plan. And then once that's all been done, you would come into our office, and then the law requires that you have to be physically present in front of the testator in order to witness that signature. But now with this emergency order, we've been allowed to do a remote execution. So what we would do is we would either courier you our package with our documents, and then set up a Skype or a Zoom or a FaceTime call where myself and my second witness will go through the documents with you, and then we watch you physically sign your copy, we sign our copy, and then together those form a duly executed will. Right now, I do encourage my clients who are signing remotely to, once this all has cleared up, come back in and we'll sign in front of me, just to make sure. But there are options and protections available to people now who, may be concerned about coming out to our office and doing, having any wills signed. We have our plexiglass installed, we have hand sanitizer everywhere, we're practicing physical distancing and wearing masks in our office to protect our clients and our staff as well.
Okay, fantastic. Well, thank you so much, Reshana, for the insightful discussion, because I think it's really important for people to really take this part of their planning at the forefront of everything, especially when it comes to estate planning. And so how can people get a hold of you?
So, well, I just want to say thank you for having me and opening up this discussion, because, the estate planning process can be very overwhelming for people, and they just get very caught up in having to make these decisions that make them uncomfortable or talk about things that nobody really wants to think about or talk about. But if this pandemic has taught us anything, it's that there is no better time than now to plan for these things, and we have to think about our family, our friends, and our future, and how can we help those around us to manage at that time. Our office is open 9 to 5 on Monday to Friday. You can give us a call at 905-452-7400. My extension is 22. You can ask for me, Reshana Singh, or you can send me an email at rsingh@lhlaw.ca, or visit our website, and we will be more than happy to direct your inquiry to wherever it needs to go. We are a full service law firm. We do family, civil, employment, real estate, wills and estate planning, corporate work as well. So yeah, feel free to give us a shout, and we are here.
Fantastic. Thank you so much, Reshana. It was such a pleasure. So
thank you, Zainab.
We'll continue this discussion after. Take care.
Okay.
Bye.